Colleagues and friends, good evening. My name's Andrew Christie. I hold the Chair of Intellectual Property at Melbourne Law School, but more relevantly for this evening's event, I have the privilege of being the person in the law school who is charged with responsibility for coordinating, together with our partner, the Institute of Patent and Trademark Attorneys of Australia, IPTA, for coordinating the Francis Gurry Lecture series. So on behalf of both Melbourne Law School and IPTA, I welcome you all here this evening. Thank you for coming. And that welcome is not just to the many of you in the room, but also to those of you elsewhere who are watching the live stream. Thank you for giving us your attention. This event is taking place on the traditional lands of the Wurundjeri people of the Kulin Nations. And on behalf of us all, I'll pay our respects to their elders past and present. As mentioned, the Francis Gurry Lecture is a joint event of IPTA and Melbourne Law School. Most of you, I know, have been to the lecture before, and you will know that it was established in 2009. The timing was apt because in 2008, Dr. Francis Gurry, who had already been working at WIPO for 23 years, was elected Director General of WIPO. And as Australians, we were very proud to have him as the new Director General. But I think as stakeholders in the intellectual property system, we were very pleased to have him as the new Director General. WIPO, like other international organisations such as the European Patent Office, faces and continues to face major challenges in its custodianship of a key part of the IP system. If you think about how your professional practice in IP has changed over the last decade, you have a good sense of the challenges that WIPO, EPO and other major organisations have faced. And we can be proud that Francis Gurry, after whom the lecture series is named, is bringing and will continue to bring intellect and pragmatism to WIPO's response to those challenges. The lecture series has been very generously and importantly supported by the whole of the Australian IP stakeholder community. The IP Office in Australia, IP Australia, from the very first has been a generous sponsor of the Gurry Lecture Series, as has the organisations that represent the professionals who work in the IP field. And in particular, I mean AIPPI Australia, FICPI Australia, and the Intellectual Property Society of Australia and New Zealand, IPSANZ. So to those generous and continuing supporters of the Gurry Lecture Series, I give my sincere thanks. I now call upon Jennifer McEwen, IPTA Counsellor, to introduce tonight's presentation.
On behalf of IPTA, I'm very pleased to introduce to you our speaker for this year's Francis Gurry Lecture. This year, we are in a unique position as we have two of the most senior officials of the European Patent Office involved in the lecture. The lecture itself has, I understand, been prepared by or under the direction of Mr. Benoît Battistelli, the current president of the European Patent Office, who sadly was unable to be with us here tonight due to personal reasons. The lecture will therefore be delivered by the very eminent Dr. Margot Fröhlinger, Principal Director for Patent Law and Multilateral Affairs at the EPO. Dr. Fröhlinger graduated from Saarbrücken University with a degree in law in 1976 before obtaining the postgraduate German professional law qualification in 1979 and a doctorate in law from Trier University in 1981. From 1979 to 1983, Dr. Fröhlinger worked as a senior assistant and lecturer in constitutional, administrative, and European law at Trier University. She was then appointed a judge in 1983 and worked at several courts in Germany until 1987 when she joined the Commission of the European Communities. Her first posting was in the Commission's Directorate General for Competition. In 1994, Dr. Fröhlinger was placed in charge of different policy areas in the Commission's Directorate General for the Internal Market, where since 2006 she has worked in the areas of intellectual property, including the creation of a unified European Patent Court and the Unitary Patent. In April 2012, Dr. Fröhlinger joined the EPO in her current role, where she's involved with the development of patent law at European and international levels, patent law harmonization, cooperation with major IP officers, including the IP5 officers and trilateral officers, and the strengthening and improvement of the PCT system. Please welcome Dr. Fröhlinger.
Good evening, ladies and gentlemen. I'm very pleased and honored to be with you tonight and to give you a presentation on the European patent system. I also send the greetings of our president, Mr. Benoît Battistelli, who unfortunately was not able to come to Australia because his daughter, sadly, on Friday was involved in a car accident. But he sends his greetings and he hopes that you will bear with me and my colleague Niklas Mori tonight. And I would also like to warmly thank Melbourne Law School and IPTA for having organized this event. And I look forward for a challenging and interesting discussion after my presentation. So my presentation will address the following three topics. I will first speak about the European Patent Office and the European patent system. Second, I will try to explain how the EPO is serving the global economy by exporting its patent quality. And third, I will try to explain how patents and innovation are in action in Europe and at a global level. So first, an overview over the European patent system and the European Patent Office. The European Patent Office is an organ of the European Patent Organization, which is an international organization and has nothing to do with the European Union. It's totally independent from the European Union, and it's wholly and exclusively dedicated to the patent system, to the search and examination of patent applications, and the diffusion of patent information. It has an annual budget of US $2.6 billion, quite important as you see, and it's totally self-financed. So we do not get any funding from any of our contracting states. We have currently 38 contracting states. Among them are all of the member states of the European Union, 28 member states of the European Union, plus 10 non-EU member states, such as Switzerland, Turkey, Norway, and some others. And in addition, we have 2 extension states, Bosnia-Herzegovina and Montenegro. These are 2 countries which are due to become, in due course, contracting states of the European Patent Organization, but not yet. And then we have something, this is a totally new concept, we have so-called validation states. These are states outside of Europe, which are not supposed to become in the future contracting states of the European Patent Organization, but which recognize European patents and provide protection at the request of holders of European patents. And there are more of these countries in the pipeline, Cambodia, Laos, Brunei, but I will come back to the concept of validation countries later. The EPO, the European Patent Office, at a glance. The European Patent Organization and the European Patent Office are the second largest intergovernmental international institution in Europe, become directly after the European Union and its institutions. And we are a global player and have a voice in Europe and at international level in the patent system. We are in charge of delivering European patents, and we will in the future be in charge also of delivering and administering the unitary patent, and I will shortly explain the new system comprising of the unitary patent and the unified patent court. We attach a lot of importance to quality. We are therefore ISO certified, but I will come back to this also afterwards. And we have more than 7,000 employees, among them 4,400 highly qualified examiners. Our mission is to support innovation, competitiveness and economic growth in Europe. We have the task to provide access to patent protection on a large geographical scope, and that is the reason why we have engaged in the policy of validation agreements and also in PPH arrangements, which I will explain later. We have the task to grant high-quality patents for Europe and beyond, and we have the task to promote access to patent information. The role of the EPO in the European grant procedure: we have in Europe, under the European Patent Convention, a centralized procedure for granting European patents. These patents have the potential to provide protection in our 38 contracting states, plus in the 2 extension states and the 3 validation states. And we are granting patents and we are working in 3 official languages, in English, French, and German. This is a brief overview over the European patent granting procedure. So you file, if you want a European patent, you file a European patent application. You receive, on the basis of your European patent application, you receive a first product from the European Patent Office, which is a search report combined with a preliminary opinion on the patentability. According then to the search report, there are different scenarios. Either the search report is positive on the patentability, then you go to substantive examination, which can result in the grant of a European patent. Or the search report is negative, then you have the possibility either on your own initiative to withdraw your European patent application, or you proceed because you know better than the examiners, but then you will face a refusal of your patent application, and then you can still go into appeal before our boards of appeal. Now I come to the new concept of the unitary patent. Now, currently, our centralized grant procedure at the European Patent Office is a real success story, and I will show later figures for, and we show also the steady increase of patent applications and granted patents. However, we have a drawback in Europe, that is that after the grant of a European patent by the European Patent Office, we have a fragmented post-grant procedure. If you get a patent from the European Patent Office, these patents has the potential to provide protection in 38 contracting states of the European Patent Organization. But in order for this protection to become effective, you need to validate your patent country per country with the national offices. And that means you have to provide, in many countries, you have to provide translations of your patent. You have to get these translations published by the national offices. You have to undergo a procedure at the national offices, different procedures in different languages. It's all very complicated, and normally, because of the complexity, you have to employ local patent attorneys to deal with all these procedures, which becomes, the more countries you validate, can become very, very costly and very complex. Afterwards, To maintain your patent, you have to pay annual renewal fees to each national office where your patent has been validated, again in different procedures, different deadlines, different currencies also partly, and that means again complexity and costs, because you have to employ local patent attorneys in order to deal with this, or specialized service providers. And the unitary patent now serves to remedy this fragmentation. The unitary patent is not a new autonomous EU right. It's just a European patent which is granted by the EPO under the current rules of and procedures, but it can acquire unitary effect after grant, and that means if you get unitary effect, which can be requested from the European Patent Office, then you have automatic protection in all of the countries which participate in the unitary patent. So you do not need to go anymore through these national validation procedures. You have one centralized validation procedure, one single administrative step at the European Patent Office, which is a major simplification and a major reduction of costs. The unitary patent will not replace the current European patent and the current possibility to validate the patent country per country. Both routes will coexist. The unitary patent is just a new additional option for patent holders who want to have protection at a large geographical scale without having to deal with a panoply of different national offices. And the unitary patent comes also together with a uniform litigation system, with the Unified Patent Court, because today you do not have to deal only with, you have to deal not only with all these different national offices, you have to deal also with all the different national courts. As soon as you have to enforce your patent in court, or as soon as you have to challenge a patent of a competitor in court. So, and this again results in high complexity and costs. If you have to litigate in multiple jurisdictions, you have to employ lawyers' teams in different countries, and that's highly costly and highly complex and legally insecure, because very often the different national courts come to different conclusions and render conflicting judgments. Now, the unitary patent comes together with the Unified Patent Court, in abbreviation UPC, and there is a certain complexity here also, that the unitary patent is created by the EU, by 2 EU regulations. But the Unified Patent Court is not created by an EU regulation, but by an international agreement of the member states who participate in the unitary patent. Why is that? Now, because the European user community has been very, very strongly arguing for an independent, specialized European patent court, which is not attached to the European Court of Justice, because they want something independent, specialized, with specific rules and procedures, and which involves also technically qualified judges, which would not have been possible at the European Court of Justice. But this international agreement, in order to enter into force, has to be ratified. And in order for it to enter into force, we need 13 ratifications, 30 countries, among them obligatory Germany, France, and the United Kingdom. These are the countries which have ratified so far. 14 we have so far. In addition, 4 more have received already parliamentary approval for the ratification. But we have, as some of you who follow this project in the specialized press or on the blogs, some of you may know that there are 2 question marks. First question mark has been, until very recently, the United Kingdom. because the United Kingdom has put on hold the ratification process last year after the referendum on Brexit. And there was some debate whether the United Kingdom could or should still go ahead with the ratification of the UPC agreement. This has been settled in the meantime. The ratification process in the United Kingdom is on track. And there is no contradiction between the United Kingdom's decision to leave the European Union and the ratification of the Unified Patent Court, because, as I said, the Unified Patent Court is not an EU court. It is an independent international court, so the United Kingdom can stay. But now we have a new problem with Germany, because in Germany there is a constitutional complaint which has been filed by an individual citizen against the ratification of the UPC agreement. Now, this is nothing very surprising in Germany, because in Germany there is a culture of individual citizens bringing constitutional complaints almost against every law and against every ratification of an international treaty. And therefore, it's not a surprise that we have this in this case also. And pending the outcome of this constitutional complaint, the ratification by Germany is pending. But we still hope that this will all be resolved rather quickly and that the new system will enter into operation in 2018, presumably in the second half. Now, as I said, I want to show the success story of the European Patent Office, the very high level of patent applications we get both from Europe and from around the globe. The level of European patent applications is more or less stable. However, we have in the first half of this year already an increase of 5.3%. And this may be interesting for you. This is the origin of European patent applications in geographical terms. So we have 52% of our applications coming from outside of Europe, and 48% come from within Europe. Among the non-European countries, it's not a surprise, the most important user community we have in the United States, which account for 25% of European patent applications, followed by Japan with 13%, South Korea with 4%, China with 5%, and others with 5%. Australia obviously is among others, but Australia ranks among the 10 top countries from which we get patent applications from outside of Europe. And among our member states, the most important country from which we get applications is Germany. This is the evolution of Australian applications at the European Patent Office. You will see the level is also more or less stable. We had a slight decrease last year, but this has been recuperated already. And in the first half of 2017, we had an increase of 6.5%. These are our 10 top applicants. You will see among the top applicants at the EPO, we have some European companies, number 1 Philips, then we have Siemens, BASF and Bosch. Number 2 is Huawei from China, and then we have 2 Korean companies, Samsung and LG, and some Americans. So that should normally not be a surprise. These are the top Australian applicants at the EPO, and there is something very special, because normally among the top applicants from individual countries, we have normally only big multinational companies. And Australia is special in that under the top 10 applicants, we have these universities. So that really shows that the universities in Australia are not only at cutting edge as far as research and innovation is concerned, but that contrary to universities, for instance, in Europe, they are very well aware of the value of a patent portfolio, and they are making good use of the patent system. So this is really something which is characteristic for applications from Australia. These are the leading fields of technology of our top applicants. So we have on top medical technology, followed by digital communication, computer technology, electrical machinery, and at the bottom, rank number 10, we have biotechnology. This is a graph which shows the flow of patent applications between the EPO and other IP5 countries. IP5 being Europe, US, China, Japan, and Korea. So we hear very often in Europe from some opponents of the patent system that Europe is flooded by patent applications from abroad. And that is not good for innovation and the freedom to operate of European companies. But this is absolutely not correct, because you can see from this graph that Europe exports much more patent application than we import from other countries. Let's have a look, for instance, at the flow of patent application between Europe and the US. So you will see Europe has imported from the US 40,100 patent applications, but at the same time we have exported twice as much patent applications, 94,500. And now I come to the second part of the presentation, and I'm rushing a little bit because I have been asked by Andrew to be quick in order to leave enough time for the discussion afterwards. So I come already to the second part of my presentation, the EPO serving the global economy by exporting its patent quality. Now at the EPO, we have the motto quality first, and we attach a lot of importance to ensuring a high quality of our products, of our search reports, of our examination, and of our granted patents. And we have a number of tools in order to ensure this quality. So first of all, our whole process end to end is certified by ISO 9001 to safeguard the quality of our processes, and we are so far the only patent office which has been ISO certified. Then we have continuous consultations with our users. We are organizing dedicated meetings on quality. We call them Partnership for Quality, meetings with our users in Europe, the US, Japan, China, and Korea. And at these meetings, we present the current state of play of our procedures, of our products and services. But most of all, we are asking for feedback from our users, and we ask our users where they see room for improvement, and normally then we take this on board and we try to improve if there are little problems in the process. And you here today, you have also in the following discussion the possibility to draw our attention to problems you may have experienced or you may have perceived, and we will then try to improve. So please use this opportunity. Then we are currently monitoring our user satisfaction. We are carrying out continuously user surveys, and normally the reply is that 96 of our users, 96 of the respondents are very satisfied, or average satisfied. Now, average satisfied is maybe not the best reply, but in general, they are satisfied. And we are also followed by dedicated surveys. For instance, the survey of IAM, an internationally renowned dedicated journal in intellectual property, and they have again ranked us this year, and they are ranking us continuously since 2010 as the best patent office globally in terms of quality. How do we achieve quality? Now, first of all, we have 4,400 highly specialized examiners. These examiners are intensively trained. They receive training for 2 years before they can work independently. And in addition, our examiners do not work on their own. We have no single examiners carrying out searches or examination. Our examiners work in a division of always 3 examiners. So we have always a double and cross-checking, and that is one of the means to achieve very high quality. We are also permanently trying to increase the numbers of our examiners, and we are continuously creating new posts. Since 2010, we have created 418 new posts, but we don't increase our overall workforce. We redeploy people from other support departments, from support services, to transform them into examiner posts. And what is very important, we constantly invest into new IT tools, search tools, classification tools, support tools for the examiners. And between 2013 and 2017, we have, for instance, invested 62 million euros just in new IT tools for our examiners. Moreover, I come to the second column. We do not outsource any of our work. So there are other patent offices around the world who outsource part of their work. For instance, some of you may know that the US Patent Office outsources its PCT searches, with the result that it is generally felt that the quality is not very good. And the USTPO itself does not recognize search reports from the international phase. Even PCT application enters into the regional phase. So the search is carried out again. That's not the case at the EPO. We carry out all our searches our own, and that means also we recognize our searches from the international phase in the regional and national phase. We have the world's largest database of both patent documents and non-patent literature. We have 1 billion records, and we have very much increased our access to patent documents in Asia. We have access to 50 million original patent documents in Asia. This is very important, since in a number of technologies, the prior art is more relevant often in Japan or China than it is in Europe, even in certain technological sectors. And that has been perceived as a weakness, not only in the European patent system, but also at other patent offices, that it is so difficult to research for prior art in Asian documents. So we have now full access to all these Asian documents, and we have not only access to these documents, we are also able to read them, because we have a highly sophisticated automatic patent translation system, which we have developed in partnership with Google. This system exists in 28 European languages, in addition in Japanese, Chinese, Korean, and Russian, and that allows our examiners not only to have access to Asian documents, but also to read and to understand them. Now I come up to another pillar of our policy, which is timeliness. Because for years, and I see some people in the audience laughing, for years we have been told by our user community, it's all very nice, you deliver high quality products and services, and you are recognized for this, and we appreciate this. However, you are a little bit slow. And it is true, like other patent offices in the world, we have to face an ever-increasing number of patent applications which are also becoming more and more difficult to search and to examine given the rapid pace of technological development. And over the years we have accumulated quite a substantive backlog, and therefore we had also quite substantive pendency. But we have introduced a new policy, early certainty, and we have now these 3 deadlines, which partly are already implemented and partly will be implemented over the coming years: 6, 12, and 15 months. 6 months is the maximum target for the delivery of search reports, and not just search reports, but search reports accompanied by a preliminary opinion on the patentability. And this we have already fully achieved, because our actual search timeliness limit is 4.9 months. Then we are also significantly reducing the time for examination. The target is 12 months from the date at which examination is requested. And this we will need a little bit more time to implement. The target is to implement this by 2020. And actually, currently our examination pendency is at about 22.6 months. And finally, we are also reducing the time for oppositions. The aim is to bring down the opposition procedure to 15 months. And this needs also some time to be fully implemented, since currently we are at 23.7 months. But you will see in the future there will be a combination of quality and timeliness. And these are 2 pillars which for us have to go hand in hand. Now you see also why it is, after all, not only difficult for us to implement this new policy, but that we are also achieving amazing results, because this is the evolution of granted patents. And you see that between 2012 and 2016, the number of granted patents has increased from 65,655 to 95,940. And in the first half of 2017, we have again seen an increase of 11.5%. How do we achieve this? Because there is some concern voiced that we do this at the expense of quality, that we are bringing down quality in order to increase productivity and in order to increase timeliness. Well, this is not the case, because what we have done is we have achieved this result by 60% due to productivity gains and 40% due to capacity increase, because as I said, we are constantly increasing the workforce of our examiners. And the productivity gains are partly due to efficiency gains in the procedure, are partly due to the fact that we provide our examiners constantly with better tools and better support, but they are partly also due to the fact that we have increased the individual productivity of our examiners by, for instance, introducing a new career system which is not based on seniority anymore but on performance, and that has produced immediate effects. By this new policy, we have managed to reduce our stock, our backlog, by 25%. We have increased, as you have seen from the figures on the previous slide, the number of granted patents by 40%. But we have also, and that is important, achieved to reduce our unit costs. So our unit costs have been reduced by 20%, and that has allowed us also to keep our fee level steady, not to increase our fees, but even to decrease our fees in certain areas. So, and this is what we are trying to achieve now also at international level, because we are at international level a very important global player in the international PCT system. So we are number one as far as international search reports and international preliminary examination reports under the PCT system are concerned. You see, our market share is 35%, and this is significantly higher than all of the other important PCT authorities. Apart from our involvement in the PCT system, we have also in recent years engaged in the PPH system, the Patent Prosecution Highway. And there we have bilateral PPH arrangements with all these partner offices, which you see at the right side of the slide. The PPH works in the following way, that if somebody, this is very important for users who go in particular from the European Patent Office to other offices, if they go with an international search report with a written opinion which is positive, then they can receive not only at the EPO but at all our partner offices an expedited grant. And that is in particular important at those partner offices where you have to pay a very high price for accelerated procedures, like at the USTPO. Then I come to the concept of the validation agreements, which were mentioned already at the beginning of the presentation. Now, the first validation agreement which we managed to conclude was with Morocco, followed by a validation agreement with the Republic of Moldova. And we have pending agreements in Tunisia, Laos, and Cambodia. And Tunisia has already been signed very recently at the meeting of the General Assemblies in WIPO. And it will come into operation on the 1st of December 2017. And future possible candidates for such validation agreements are Angola, Brunei, OAPI. OAPI is the Organization of French-Speaking African Countries, Malaysia and Jordan. So the interest for holders of European patents is that they get a foothold in other parts of the world with the validation agreements, and that they do not need to go through lengthy, unpredictable procedures at national patent offices in those countries, but that their European patent protection becomes automatically valid in these countries. And the more we will extend our validation agreements with other countries, the more the European patent will really become a global patent. And now I come to the last part of my presentation, and I'm really good in time now. Because yesterday evening he had to interrupt me. Now, so the third part of my presentation, patents and innovation in action. We are trying to promote the patent system and to improve the public perception of the patent system through a number of different tools. And one of our tools is the European Inventor Award. Now, this is an annual award which we have established in order to honor inventors in different categories from all over the world. It's a very beautiful event which is hosted every year in a different location. And we had also a very important inventor who in 2015 has won this award, Professor Jan Freyser. And for his invention of a vaccine against clerical cancer. Presumably most, if not all of you know Professor Freyser. Sadly, the co-inventor, Zhan Su, has died many years ago, but the prize was collected for him also by his widow. So this vaccine disrupts the link between the human papillomavirus. Do you pronounce this papilloma? Papilloma, okay, a sexually transmitted virus infecting the skin and mucosal tissues, and it causes cervical cancer. This is a real success story because not only has he won the European Inventor of the Year award, but the vaccine is now used in 120 countries around the world and has been administered more than 125 million times worldwide. And this is considered as an invention which changed women's health forever. This is a picture from the 2015 European Inventor of the Year event. You see to the right our president, Benoît Battistelli. Unfortunately, he has not been able to come, but at least you see him on the picture. Next to him, you have the widow of the co-inventor, Zhan Su. Then you have Professor Jan Freyser. And to the left, you have the former commissioner of the Chinese Patent Office who handed over the prize to the widow of co-inventor Zhan Su. I come already to my conclusions. The EPO today is a modern public agency that proved capable of reforming itself while increasing efficiency and quality, which cannot be taken for granted for a public service. You know, presumably also here in Australia, how difficult it is to reform public services, especially huge entities as the European Patent Office and the European Patent Organization are. But we have managed, thanks to the effort mainly of our president, Benoît Battistelli, to carry out all these reforms and to become a really modern public agency, service-oriented, and with high efficiency and quality. The EPO is a European success story with a global role, as you have seen from all our activities in the PCT, in the PPH, and our new policy of validation agreements. The European patent system will continue to expand and increase its international influence. Last not least also because we are providing the world's most important databases, and we make these databases and our patent information available to patent offices and to users around the globe. And the EPO is also ready for the unitary patent, a long-awaited step in the evolution of the European patent system. If you need more information, you can follow us on all these social networks, on Facebook, Twitter, YouTube, LinkedIn, but you can also contact us via EPO.org contact. And you are also free to send emails to my colleague Niklas Mori and to me. And with this, I thank you very much for your kind attention, and I'm looking forward to interesting questions. Thank you.
Margot, thank you very much for that quality and efficiency presentation. Emphasis on both of those. Efficiency such that you've left us with very good time to ask questions of you and Niklas, make comments about things you've said. We have microphones for those questions and comments, so please indicate by raising your hand when you have a question or comment, and we'll bring you a microphone. And while that's being brought, I might just add for the people watching the live stream, as you know, you can send us your questions or comments using the Twitter hashtag Gurry17, and we'll monitor that and raise it for you. Thank you.
Brendan Whitty, University of Oxford. My question, which I hope doesn't sound too parochial from the British side of things, was your statement about the independence of the Unified Patent Court from the European Court of Justice. How confident are you that in the long term that is likely to be the case, given the obligations to refer questions insofar as EU patent law develops over the coming years?
Shall I answer immediately? Well, I may not have been entirely clear. I tried to say that the Unified Patent Court is independent from the European Union. It is an international court, it is not an EU court. But it is not entirely independent from the European Court of Justice, because it is under an obligation to respect the primacy of EU law, and it is under an obligation to refer questions of the interpretation of EU law to the European Court of Justice, and to respect the judgments of the European Court of Justice. Only that, there is not much European law in the area of patents, because the validity of patents is exclusively governed by the European Patent Convention and the implementing rules to the European Patent Convention. The scope of protection and the limitations and exceptions from the scope of protection, the remedies in case of infringement, they are covered in the agreement on the Unified Patent Court, because the agreement on the Unified Patent Court concerns not only organizational and institutional provisions, it concerns also a whole body of substantive law. And some of this substantive law, by the way, has been transferred from the EU regulations, which create the unitary patent. They have been stripped from the regulations, have been transferred into the agreement on the Unified Patent Court in order to make them part of the international agreement, so that they are not EU law anymore and do not have to be referred to the European Court of Justice. So there is very little EU law. There is, in essence, there is only the SPC regulation, Do you have a supplementary protection certificate?
equivalent.
Yeah, you have an equivalent. So there are EU regulations on supplementary protection certificates, and there is the biotechnology directive. But the biotechnology directive is applied by the European Patent Office via the implementing rules of the European Patent Convention. So there is hardly anything which will go to the European Court of Justice.
Quick follow-up. I think that's very interesting. It shows a lot of confidence in the organs of the Unified Patent Court finding any raising of a EU law issue to be utterly non-justiciable before them. I'd be intrigued as to whether, at what stage, if some plausible issue is raised, that a question gets referred to the Court of Justice, who suddenly, lo and behold, like many judicial institutions over the years, discovers that it actually has some jurisdiction on some EU law issues, whether it be proportionality of remedies or what have you, some due process issue. I'm intrigued as to whether you have great confidence in no litigants bringing those matters up and the Court of Justice not taking them up.
No, I don't have great confidence that nobody will bring this up. This will be brought up. Only that I said the areas are very, very limited, because you may think that there is a lot of jurisprudence of the European Court of Justice and of the General Court, which is underneath the European Court of Justice, in the area of trademark. But there we have a different situation, because the EU trademark is entirely governed by an EU regulation which sets out the conditions for trademark protection, for getting a trademark, for maintaining a trademark, for using a trademark, etc. But in the area of patents, the scope of EU law is really very limited. But these very limited questions will certainly be brought to the European Court of Justice. That is clear. And the Unified Patent Court will have to refer these questions, because not only is the Unified Patent Court under an obligation to refer these questions, but there are also sanctions in case the Unified Patent Court does not respect these obligations. The member states who are participating in the agreement are liable, and individual parties can even go to the national courts and ask for damages for a violation of the obligation of the Unified Patent Court. But I'm very much delighted that there is this level of sophisticated questions here.
Sorry, you use the microphone. Thank you.
Yes. I just have a question which you might already answer something, but I just want to ask again. For the individual patents which has been registered in the home countries, do you think there is a particular advantage of registering with the EPO, or just leave it as they are and then let them resolve? That means, is it better to re-register the patent through the EPO? Because as you said, it's encompass more countries in Europe.
Well, it depends, of course. We have in Europe coexistence of national patents and European patents granted by the EPO. And it may be, for some companies, it may be interesting to have national patents. But as soon as a company really acts at a cross-border level, it does not make much sense to have patent protection only in one or two countries. So it's much better to rely on the broader territorial scope which a European patent can provide. So therefore, from our point of view, I do not want to stress again that maybe our quality may also be better than the quality of some of our national offices. So that may be another reason to go to the EPO instead of going to national offices.
Hello. I have a question regarding a patent going to Europe. a patent may be going to Europe through EPO office, and can also go into after going to EPO office and then go to each country. And in this situation, because the EPO regulation and the national regulation in some situations is not exactly the same. So a patent may be valid under the EPO regulations, but invalidate and maybe national regulations. So for example, in German's regulation may be different from a little bit different from EPO regulation, and a patent first go into EPO and then go to German, and maybe first validate and the EPO granted, and after that they go to German, invalidate. How to address this kind of question?
There may be a misunderstanding here. If a patent is granted by the European Patent Office, this patent is, if it is validated, is valid everywhere under the same conditions, because the validity of the patent is governed exclusively by the European Patent Convention. It's not national law which applies to the validity, it's only the European Patent Convention. We have, however, one problem, that is, if the validity of a patent is challenged in court, it is challenged in court country per country, before different national courts. And different national courts may take different decisions, but not because they apply national law to the validity, but because they interpret the same provisions of the European Patent Convention differently. But it's always the same rules which apply, only that different courts interpret them and apply them in a different way. And that is one of the reasons, by the way, why we need the Unified Patent Court, in order to achieve also a uniform interpretation of the provisions of the European Patent Convention. So validity is exclusively governed by the European Patent Convention. Something different applies to the scope of protection, the limits and exceptions, and also the available remedies, because this is governed by national law. So for infringements, there are different rules applicable country per country. And then, of course, again, different courts take different approaches.
Sorry, can I clarify? I will clarify my understanding. Is that right? That if a patent, even if a European patent, go into the national, each national, and to determine the validity of the patent, is still use the EPO regulation, not the national regulation. Okay, thank you.
It's only the European Patent Convention which applies to the validity.
Number down here, we'll take them in order. Yep. You can.
So what you just described does sort of point to the fact that litigation can be expensive if a business is looking at a wider geographical territory in terms of their patents. And I'm coming from a perspective of an insurance specialist in the space of intellectual property. Mm-hmm. And my clients do ask me for infringement as well as defense coverage. So, and insurance companies do provide, do sort of have some level of say in terms of how far the litigation can go. But I'm just thinking that, does the EPO see itself as a moderator, and do you see yourself at some stage looking at mitigating the cost of, enforcement when it comes to infringement of intellectual property?
No, because the EPO has a twofold mission. We have the mission to search and examine patent applications and to grant patents, and we have the mission to diffuse patent information. But we have no role in the enforcement of patents. So the enforcement of patents is for national courts and in the future for the Unified Patent Court also. But it's not in our mission, and we cannot, on our own initiative, without a modification of the European Patent Convention, go into these areas.
I wonder if you could comment on what level of opt-out you're expecting out of the unitary patent system and the reasons for that.
Okay. For those of you who may not be familiar with the issue of opt-out, the Unified Patent Court has jurisdiction both for unitary patents and for European patents, for classical European patents which are validated country per country. For unitary patents, this jurisdiction is from the beginning exclusive. So a unitary patent can only be enforced and can only be challenged before the Unified Patent Court. For classical European patents, there are two possibilities to still litigate before the national courts. So first of all, there is a transitional period of 7 years where parties can choose, instead of going to the Unified Patent Court, to go to national courts. And that is both for the patent holder and also for a competitor who wants to bring a nullity action, who wants to challenge the patent in court. In addition, during these 7 years, a patent holder has the possibility to withdraw his patent from the jurisdiction of the Unified Patent Court. This is the so-called opt-out. This has been provided, this possibility, in order not to force parties into this Unified Patent Court if they are afraid for whatever reason of the Unified Patent Court, but to give them the possibility to continue to litigate before national courts during a transitional period which the Unified Patent Court may need in order to build up sufficient trust and confidence with all patent holders. Now, the issue now whether a company, a patent holder, decides on whether to opt out a patent from the jurisdiction or whether to leave a patent in the jurisdiction is very tricky, because there are many different considerations. And it's very difficult to predict to what extent patents will be opted out from the jurisdiction of the Unified Patent Court. And I do not have a crystal ball. We expect, after an initial debate in Europe and in the United States and in some other major jurisdictions, initially there had been a debate, we will opt out our whole portfolio from the Unified Patent Court, and then we will wait several years to see how the Unified Patent Court works. But in the meantime, the debate is much more mixed. There are some big international players who are saying, well, we will in principle use the unitary patent, and that means we will in any event be under the jurisdiction of the Unified Patent Court. Some of our patents, our blockbusters maybe, we will continue to go down the classical European route, and then we will opt them out. There are other companies who are saying, we will go only with some of our patents into the unitary patent and in the Unified Patent Court in order to see how it works and in order to be involved from the beginning and in order to be able to shape the new system by being in it. So we simply do not know. And the debate is changing all the time also.
Do you have a question? I've got one down the front.
Thank you. First of all, congratulations on speeding up the rate of examination. And quality is very subjective. So a question I have is, what will you use to measure the quality of the speeded up examinations? And would pre-grant oppositions be one of them? And the success of pre-grant oppositions be a measure as well?
Well, with your consent, I would like to pass these questions to our newly appointed Principal Director for Quality Management, Mr. Nicholas Morey.
Yeah, thank you. Thank you very much. So basically, when it comes to the speed, so we believe that speed is in fact quality, and therefore we have put these three magical numbers up as our goal that Margot showed you. So 6, 12, and 15. So 6 months to have the search ready with the opinion, 12 months for the examination, and 15 months for the oppositions. These are averages, but we are now working very, very hard to get these down by 2020 to actually achieve these timelines that we have now set for us. We've had cases where pendency has been very long. I'm sure that you maybe have cases by yourselves as well, and we are now dealing with all those to bring them down considerably. That is our now mission, should we say. We've already completed this for the search. We're actually at 4.9 months instead of 6. But we still have a lot of work to do in the area of examination and opposition. But by 2020, we will be bringing these down to these numbers that we showed. In fact, while doing this now, we're in a bit of a dilemma because some companies are saying, well, 12 months examination is fine, but in general, for 80% of my cases, but I have cases where I need more time. I'm discussing with potential licensees. So I would like to have more time than these 12 months, and can I then delay? So that's the other side of the coin, and we're looking into perhaps also possibilities where the applicant may wish to delay the process in certain areas of technology, for instance. One is, for instance, when you have patents and standards. So when you have patents being part of a new standard coming out, then even the high-tech companies who are developing parts of these standards say, well, a standard takes maybe 5, 6, 7 years to develop. Therefore, we would like to wait with our patent application to see if our patent will indeed, or our application, eventually will become part of the standard. So they don't want to, in those circumstances, rush forward until they know where their patent will be within that global standard.
The question was more to do with not the quality of process or the quality of surface, but the quality of output. So, for example, if I do something really quickly, this is myself personally, by the way, I normally do it very slapdash.
Right.
Yeah? Or I do it in the quickest shortcut way possible, because it's a way of doing it quickly. So a measure of oppositions, so if the quality of patent examination goes down, logic says the number of oppositions is likely to go up, and the number of successful oppositions is likely to go up.
Quick doesn't mean a poor quality. If you look at, you have long processing times, but there are a number of steps within those processing times. The actual work that the examiner invests on average is 2 days in a product. Now, 2 days doesn't mean that he's suddenly cutting this to half a day. He's still doing the 2 days, but he could be doing it earlier. It's done in a different way, which means that you get the results more quickly, but it doesn't mean that the examiner is actually cutting corners while producing that piece of work. And this we are monitoring very closely. We have individual quality objectives, so each examiner is not only measured on production and productivity, he's also measured on the quality himself, and we have certain systems put in place at the EPO where the quality is measured. We have an internal audit. We sample the work done by each examiner, a few cases over a couple of years. So it's very, very closely monitored. But speed, and this is what people say sometimes, well, if you're doing it so much more quickly, it means that the quality is going down. No, it doesn't mean that. On the contrary, it means that we're just improving the way that we do the work, but the time that we invest in each product is not going down by a lot. Some efficiency gains, a percentage here and there, maybe 5%, but it's not that we're cutting the work that the examiner does into a fraction thereof. Okay.
There was a question up the back. No? Other?
we're talking about quality. One of the issues that has obviously been fairly big in the United States for a number of years now is that of the bad actors within the patent system that are often called patent trolls, and I'm going to limit that to those parties that are litigating, or at least threatening to litigate, patents that are widely regarded as being of low quality and of questionable relevance to the products or services that they're enforcing them against. And it seems there's been some talk of this emerging in China as well more recently, but generally in around the world, and in Europe in particular, this hasn't been such a problem. And there's some speculation that a unitary patent, which obviously opens up a much larger single market in which you could conduct these kinds of activities, might be an issue here. Now, do you think that that's the case? And do you believe, since you're both standing up there, that the quality and the quality of the product that you were just talking about is an important factor in whether or not that kind of activity actually would grow under the unitary patent system?
Okay. Of course, quality is an aspect in this phenomenon of patent trolling or patent asserting or non-practicing entities, or however you call them. But more importantly is the way the court system works. And we have to look into the factors why patent trolling has become such an attractive business model in the United States, and why it is quasi absent in Europe. There are some cases, but it does not have the same dimension. Now, first of all, in the United States, a non-practicing entity has no litigation risk, because on the one hand, they pay their own lawyer only when they win, because they pay on the basis of a contingency fee, and they do not have to reimburse the lawyer's costs of the other party in case they lose. So they have no litigation risk. That is totally different in Europe. In Europe, contingency fees are prohibited, and there is a general loser pays rule. So whoever the losing party always has to reimburse the costs for legal representation to the winning party. And that is the case already at national courts, and that will also be the case at the UPC. Second, the litigation risk for the other party is very high. And this is also why the other party very often says, okay, hands up if they get a letter from a patent troll. I do not take the litigation risk. And why is that? Because first of all, even if they win, they will not get their costs reimbursed from the non-practicing entity. Then they are at risk that the costs are very high, because the litigation costs in the United States are much, much higher than in Europe for a variety of reasons, including the system of discovery, for instance. And if they lose, they are at risk of being faced with damages which are absolutely excessive, because the US courts are in the habit to award damages which are unheard of in Europe. Punitive damages, for instance, are prohibited in Europe under the Enforcement Directive. And then there are additional procedural guarantees inbuilt into the rules of procedure at the Unified Patent Court. Like, for instance, that if a party is a non-practicing entity, then a first instance judgment cannot be, the judges can order that the first instance judgment cannot be enforced without an appropriate security, and a number of guarantees of this kind. So therefore, all the expert patent judges and lawyers who have been closely involved in the preparation for the Unified Patent Court and in the drawing up of the rules of procedure, etc., they are unanimously of the opinion that the Unified Patent Court and the Unitary Patent will not give rise to the emergence of the same phenomenon as in the US.
Thanks. Okay, there's no more questions or comments, I take it. Therefore, I will call on the President of IPSANS, Luke Merrick, to bring our evening's proceedings to a close.
Thanks, Andrew. It's my pleasure to briefly thank some of the people who've been involved in this evening's lecture. First of all, I should, of course, thank Mr Battistelli for all of his work in preparing the lecture. And of course, on behalf of all of you, I wish him and his family well in light of the events which prevented him from coming. And we hope that we might see him in Australia on another occasion. Can I also thank Dr Fröhlinger for her very informative and useful lecture. It's an awfully long way to come on short notice, so we're very grateful to you. And we hope you enjoy the rest of your stay in Australia, no matter how brief it might be. Can I also thank, and I think this is particularly important in light of something that Andrew said earlier, I think the university, and in particular Andrew, needs to be thanked for his leadership in developing this lecture series, which has rapidly become one of the premier intellectual property events in the country, and I commend him for that. And can I simply say on behalf of IPSANS, and I'm sure this is a sentiment that the other parties involved in supporting the lecture share, we look forward to supporting this lecture long into the future, and I'm sure it will continue to retain its status as a preeminent IP event in the country. Thank you.